So bioethicists will argue both sides of the killing versus letting die debate. Is it more compassionate to simply kill an impaired person than to let them die slowly by foregoing treatment? Or in is it more ethical to let them die slowly so that an error can be corrected or a decision can be changed, and have the family have to go through that process than killing them, in which time is quick and done. You can't go back. It's a final decision. So, in deciding to forego treatment and infanticide, the motive, which is death of the baby, is the same. And so is the result, death of the baby. So if both decisions have the same motive and if both lead to the same outcome, do they differ morally? And that's the debate that goes on. Much of the debate that was happening at the time of both Baby Doe cases was really surrounded by the degree or the level of impairment. So in practice, criteria for non-treatment of impaired babies tended to be based on the long-term prognosis and the degree of defectiveness. Baby whose problems were deemed to be less serious should be treated, whereas it would be permissible to let babies who had more serious or more gravely ill impairments would be more permissible to let them die. So, cases between these two extremes, such as those with babies with spina bifida and babies with Down syndrome, created the controversy because the prognosis is really far from absolute and far from well understood. We understand that more now, that there's a range of abilities and disabilities, but back when these Baby Doe cases, which really wasn't all that long ago, there wasn't the level of intervention available for these infants and for the families. So the level of impairment wasn't well understood. So, the prognosis for particularly the intelligence of these babies with impairments is often influenced by the social views, and Down syndrome is a perfect example of that. In the last 50 years or so, the change in thinking about the abilities of people with Down syndrome has been dramatic. And we recognize that, even with generally low IQs, there is still a level of quality of life that can be achieved by people with Down syndrome. IQ is a measure of intelligence, but it doesn't necessarily relate to the quality of life. And again, as I've said a number of times, who determines what is a quality of life? So, given reasonable stimulation, love, supervision, intervention, many people with Down syndrome will live a reasonably good life. They will have their personal narrative and they will live their personal narrative. We can't say that they would be better off dead. So, with all of the stimulation, with the support, with everything that's available to them, the prognosis is much more positive than it ever has been before. So you can't predict whether, at birth, what the prognosis is going to be for these children. There's also the ethical issue of wrongful birth and wrongful life. And really, we could add in here wrongful death, which is something we're more familiar with. But parents can actually sue physicians in civil courts for allegedly causing babies to be impaired. Today, particularly, parents rarely accept birth defects as God's will or whatever, as just something that nature intended. Standards of health continue to rise, and people who have children expect to have healthy babies. And parents often blame the physicians for the birth of these impaired babies. But wrongful life and wrongful birth suits fall into a general classification of tort law And in both kinds of actions, families are seeking compensation for what they deem to be the harm that they have been caused. There have been many cases that wrongful birth or wrongful life suits have been brought by parents against physicians. There's one case in New Jersey where parents of a baby with Down syndrome sued their obstetrician, who was pro-life, whom they say discouraged them from having an amniocentesis done when a sonogram indicated the fetus had a thick neck, which is a possible sign in utero of Down syndrome, although there are other signs, and that can be indicative of a variety of things. The baby ultimately was born with Down syndrome, and the jury awarded the couple almost $2 million, finding the doctor guilty of failing to appreciate and discuss the results of the test with his patients. So there are many of these cases that come up, and it really is, again, the ethical two sides of the coin, where, do you get these testing done to determine whether the baby has a chromosomal abnormality, and then once you have the results, what is it you do with those results? And who's responsible for taking that action based on the results? And that brings us to legislation. So in 1984, Congress amended the Child Abuse Prevention and Treatment Act of 1974 to count non-treatment in the baby doe cases as child abuse. So these child abuse amendments circumvented the injunction against the baby doe rules, and they made states, not the federal government, responsible for these cases. The only exception to the child abuse amendments were when an impaired child is chronically and irreversibly comatose, or when a child is inevitably dying, and when treatment would be futile and inhumane. So these exceptions are often interpreted narrowly, so it gives parents few choices. Problems resulting from its narrow interpretation were illustrated in the Rudy Linares case, which took place in Chicago in 1989, and I put a clip up for you, a little news article. So Dan Linares, held a NICU staff at gunpoint while he disconnected the respirator of his 16-month-old son, Rudy, who, after swallowing a balloon at a birthday party, went into a coma, and 9 months earlier. He died after Dad pulled the plug, and Dad was charged with first-degree murder. Because there was no doubt that he was a caring parent, the grand jury refused to indict him for homicide, and he received a suspended sentence for a minor charge arising from the use of a gun. So, this is one of those cases where they used the child abuse amendments and determined that it was not abusive what he had done because of the level of impairment of the child. In 1992, the Americans with Disabilities Act went into effect, which protects Americans with a wide range of disabilities from discrimination. In 1994, the federal court specifically cited the ADA and mandated treatment for a 16-month-old anencephalic infant. Remember, we talked about anencephaly a couple of weeks ago. This was baby K, who was brought to a hospital emergency room in Virginia, and he was in respiratory distress. Baby K had been on a respirator since birth. She. The physicians wanted to disconnect the respirator and let her die, but for religious reasons, the mother insisted on continuing care. So, at the heart of the Baby K case is about whether physicians are able to overrule parents' decisions about continuing futile, expensive treatment without incurring charges of discrimination against people with disabilities. For over a year, Baby K continued to receive treatment, but she died in 1995. The media coverage and the notoriety of these cases has ultimately led to a better understanding of how to treat people with disabilities, and also how, what the potential is, or even awareness of the lack of understanding of what a person's potential is at birth. And, it's led to a number of advocacy efforts on behalf of people with disabilities. And those advocacy efforts have further led to a better understanding. So, we now have the Down Syndrome Association, we have the Spina Bifida Associations, very active and vital organizations that help us better be able to understand what is best for an individual with this diagnosis, what is the prognosis for individuals with these diagnoses, and how to independently and individually treat these people with these diagnoses. So although the outcomes, weren't as positive for particularly infant Doe, who died in a relatively short period of time, the media attention and the notoriety of these cases have led to positive outcomes for people with disabilities. So that leads, all of this, to sum up this topic, we have a conceptual dilemma. Is it possible to both support choice and respect a decision when that choice is made? There was a family who had a child with spina bifida in 2004, and had the doctor ordered the correct tests at the time when this baby was born, it would have been aborted, and the family reported that they would have tried to have a healthy child. However, today they have this child with spina bifida, and they love this child. Can we reconcile the fact that we love a child, or that a child is loved, that would have, had things gone the way they were planned, would have been aborted? Is it consistent to do these prenatal testing for genetic diseases while at the same time we have adults with these diseases? Can we say that they are respected when we're doing tests to determine whether a fetus has this disease, and if the fetus has the disease, the parents have the option of aborting that, and yet we have adults with these diseases? Does that demonstrate a respect for the individual with a disability? So there's some inconsistencies there. It's a conceptual dilemma. Are we able to both support choice and respect the individuals living with that disability? And that brings us to the next topic du jour, which is genetic testing. Okay, so talking about pre-symptomatic genetic testing, one of the most famous cases that you probably have even heard about is Angelina Jolie. One of the few things that we're talking about in this class that has happened in your lifetime. So Angelina Jolie had decided in 2013, she wrote an op-ed for the New York Times and indicated that for a decade, her mother had fought breast cancer and ovarian cancer and died of it at the age of 56. Her grandmother died of ovarian cancer at 45, Angelina Jolie's grandmother. So, Angelina Jolie wrote that she had paid $3,000 for pre-symptomatic tests for the breast cancer 1 and breast cancer 2 genes, which have lethal variants that carry an 87% risk of breast cancer and a 40% risk of ovarian cancer. And her test came back positive for the bad variant. So given how her mother died and given her results, at age 37, she decided to have a preventive double mastectomy. 3 months after the operation, she went public, which caused a sensation. So the controversy was she had the faulty gene but didn't yet have the expression of breast cancer, and she went on to have this preventive double mastectomy, which ultimately led a lot of women to get this genetic testing done. And when they found that they may have had some variation of this faulty gene, to also undergo the same treatment as Angelina Jolie. Whereas these two particular genes that they could test for